Mr. Schumer.
Good morning, Ron.
Good morning, Mr. Schumer. How are you?
I'm well, thank you for asking, and yourself.
I am good. Thank you for asking. All right, I need to print out the documents that your attorney went over with you on the phone. Because I need you to quick review it and then to get it signed for me if you can, on top of that document. Thank you, Mr. Schumer.
I have thoroughly reread this several times.
Excellent.
So I'm well aware of all the agreements.
Thank you. I'm glad to hear that.
Yep. And I am currently in programs for change.
Oh, good. I'm glad to hear that too.
And thriving. Doing everything I'm supposed to do, basically.
So where are you taking that out of?
That's out of Amory with Brian
Oh.
Francis for programs for change.
That's awesome. That's good. Okay, I'm glad to hear that.
And Attorney Fisher, the two documents I handed your client were the DJOC, but with my signature on it and also your signature, and then the clerk printed out the plea questionnaire.
Thank you.
You can just quick look those over, and if those are the documents, then just sign them, okay? And then if you can bring them up to me, Mr. Schumer, when you're done, I would appreciate that.
There's a line here, Your Honor,
Yes?
that's checked whether or not have not or have. And it says, I have checked, had any alcohol, medications, or drugs within the,
If you need to change anything,
yeah,
change
because
it
that's
to
not
whatever-
correct.
Then just change it to whatever
Okay.
it should be.
Because it should be have not.
And I apologize, Mr. Schumer. That might have just been when we went through the app, when we went through the form. You were, I believe, taking prescribed medications.
Oh, prescribed, of course. But with it starting with alcohol, I went,
Oh.
not drunk in court. Okay, let me,
It's happened.
sure,
So it's good that
I believe it.
well, it has to be there. So this is a DJOC, and is it with the modifier or without the modifier?
Without, Your Honor, I believe the DJOC is to plead to the obstruction and the disorderly conduct will be read in.
Okay, all right, all right.
I'm almost done. Onto my email. Okay, and you would like me these two
Yes,
attorneys?
please, if you could bring them up, I would appreciate that. Thank you so much. We will go on the record in the matter 25 CM 65, State of Wisconsin versus Jacob Schumer. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Schumer in person. His counsel Zachary Fisher appears by video conferencing. We're set today in this matter for a plea hearing. The parties have reached an agreement. Mr. Fisher, please recite the agreement for the record.
Yes, Your Honor, there is a 2-year deferred judgment of conviction where Mr. Schumer will plead to obstruction, the disorderly conduct, as well as the modifier will be dismissed and read in. And then the terms of the agreement are that Mr. Schumer will continue to comply with any alcohol and drug related treatment, as well as any mental health related treatment. And he will continue to provide updates to the district attorney's office on his progress throughout the deferred period.
And this runs for a course of 24 months.
Yes.
And if upon completion and successfully completing all of the provisions Is this matter going to be, yep, the matter will be vacated and dismissed, correct?
Yes, Your Honor.
All right. Mr. Schomer, that's the agreement that you've reached with the state, correct? Is that a yes?
Yes.
Victims' rights compliance?
Yes, Your Honor.
So I have in front of me both of these documents, the plea questionnaire waiver of rights form and that deferred judgment of conviction document. Off the record, you indicated that you have reviewed and read both of these very thoroughly. You've made a change to the plea questionnaire. And so you understand these documents completely?
Yes.
And your attorney went over these documents with you essentially word for word,
Yes.
and you signed both of them?
Correct.
So you're pleading guilty to one count of obstructing an officer. The other matter would be what's called dismissed and read in. Do you understand that?
Yes.
36 years old, 12 years of schooling. You can read, write, you understand the English language. No
Yes.
drugs, alcohol, or other medications in the last 24 hours?
No.
No mental illnesses or disorder, but you are doing the programming that you've stated off the record to the
I
court?
do have a mental illness
Okay,
disorder. Small, diagnosed as a full-blown disability, multiple personality disorder.
Okay, and so you're seeing is it a psychiatrist?
I am.
And so you're handling that and dealing with that?
Mhm.
And do you have to take any medications?
Yes.
And so those medications that you've taken, do you take them as prescribed?
Very much so.
And when you take them, do they interfere with your ability to comprehend or understand?
Not at all.
Do they actually help you?
Yes.
I'm glad to hear that. All right, so did your attorney thoroughly go over with you what it would mean if the court does enter this deferred judgment of conviction?
Yes.
And that it's not essentially probation, but there's still going to be eyes on you for 24 months?
Sure.
And he went over all of those other provisions with you?
Yes, he did.
And did he also go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Lightly.
And he went over the maximum penalty you could face?
No.
I'll go over that with you
Okay.
again. And I'm going to guess he probably did, but probably briefly. And
Yeah.
sometimes there's a lot of information in it, kind of comes
Over the
on
phone.
fast.
Yeah.
Yes. So did he also go over with you your constitutional rights?
Yes.
And they're listed on the first page of both of those documents.
Yep.
So do you need me to go over those rights with you in any more detail?
No, thank you, Your Honor.
You understand them completely?
I believe so.
And you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
And do you understand that here, the state would have to prove on or around April 7th, 2025, that in Burnett County, Wisconsin, you knowingly obstructed an officer while an officer was doing an act in an official capacity and with lawful authority, and you knew that you were obstructing that officer. So do you understand what the state would have to prove?
Yes.
Do you understand maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 9 months or both?
He did mention that.
Okay. And now, do you also understand that it's the court's discretion in what a sentence is, and that would include whether or not the court accepts this deferred judgment of conviction? Do you understand that if I thought the facts of the case warranted it, that I could sentence you to the maximum penalty if I thought it was warranted?
Mhm.
Is that a yes?
Yes.
Do you still wish to proceed and enter a guilty plea?
Yes, Your Honor.
Did you go over that criminal complaint with your attorney? And in particular, there's that section, and it's called the probable cause section, and it basically says what happened that day and why you were charged with the crimes?
Mhm. Yes,
For the most part, are those facts accurate?
for the most part.
All right. Now, Mr. Fisher, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty to this charge?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily?
Yes.
And your attorney is appearing by video today. Do you understand you have the right to say, you know what? I just want to wait until he's next to me in person.
He's been very good about letting me know I can be there if you choose.
Excellent. I'm
Yep.
glad to hear that. So you're okay with him by video.
I am.
Now, has your attorney represented you competently?
Oh, yes.
He's answered all of your questions
Yes,
and he's looked at this matter thoroughly.
I believe so.
Are you satisfied with his services?
Yes.
Do you have any questions for the court or your attorney before I proceed?
No, just a thank you.
Well, I'm glad that, and I'm sure he's glad to hear that too. So as to count 2, obstructing an officer, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 2. Count 1 will be dismissed and read in for purposes of sentencing. As to whether or not the court enters judgment, Mr. Schmidt.
Judge, we're asking the court to do a deferred judgment conviction on this case for a couple of reasons. Mr. Schumer does have a criminal history, but it's nothing like this. It's OWI related. This was, as the court can tell from the criminal complaint, mental health related. He was having a mental health crisis where he was both suicidal and the victim felt he was being threatening to him because of claims of having a knife. The victim has said more recently that they believe that Mr. Schumer is successfully addressing his mental health issues now. In response to that is when I offered the deferred judgment where he'd continue addressing the mental health. Because of his lack of criminal history related to this kind of behavior and because he's treating the mental health on his own, I didn't think a conviction was necessary because I didn't need to place him on probation. He did get the initial consequence of, I think, 1 or 2 days jail before he posted the cash bond, as well as he had to be shot by the beanbag gun from law enforcement, which is very extremely painful.
Twice.
Nobody would enjoy that. So
Broke
the initial consequence was there. So I think this is appropriate. Thank you.
Okay, all right, thank you. Mr. Fisher, anything you want to add or argue?
Your Honor, I would just ask that you follow the joint recommendation. Mr. Schumer has been very adamant from the start that he understands how serious this was and that ultimately I think this was kind of, I don't want to say a breaking point for him, but I think a clarification where he realized that something needed to change, not only for those around him, but most importantly for himself. And he's shown, frankly, a lot of willingness to do that on his own. I've been more than less kind of just keeping up with Mr. Schumer and what efforts he's been making, rather than having to specifically say, go here to do this kind of services if you want this kind of result. He's taken all that initiative on his own. He understands, and he's been very, very seriously following the recommendations of his counselors and making sure that he continues to try to improve his mental health so something like this doesn't happen again in the future. So for those reasons, I would ask that you follow the recommendation.
All right, thank you. Okay, Mr. Schumer, any statement or argument or anything you want me to know?
No, ma'am. Your Honor, excuse me. I just, with being shot, it was a good enough punishment because it felt unnecessary in the situation. I may not be a know-it-all when it comes to police force, but it seemed really excessive. And to wake up in jail with broken tibia was eye-opening and a sobering moment for me in my life that I never, ever want to be back here.
And Jacob, I've had you've been in front of me before. Nothing as serious as this. And I don't like to hear what happened that day. It sounds like it was very traumatic, but it sounds like you were going through a mental health crisis. And unfortunately, it wasn't able to be circumvented prior to this. You've learned a lot.
Yeah.
And now, not that you weren't taking your mental health seriously, but I don't know what happened there, but something, either your medication was off.
I know what happened.
Yeah, what happened?
I mixed alcohol with my.
Oh, that's exactly what happened.
That's what happened. Otherwise, I'm fine. It's always alcohol.
And you understand that alcohol is poison to you.
Yeah. I've been sober since I got pulled in. I haven't had a drop.
I'm very glad to hear that. It sounds like this was a huge eye-awakening experience.
Mm-hmm.
And this is nothing that law enforcement wants to engage in, nor is it anything that you want to engage in.
Yeah.
Hopefully you're on the path to sobriety, alcohol and mixing with your medications, because it can be serious.
Yeah.
And you seem like a really sweet and kind person. And it's unfortunate that you have to live with the mental health issues that you do. But it sounds like for the most part, you do take it seriously and you understand. It's just sometimes I'm sure you were just self-medicating because I don't know why. Maybe a little bit more stress was happening that day or time or in life. But you understand now, and I'm going to accept the deferred judgment of conviction, 24 months, continue with the things that you're doing, continue to update the district attorney's office, not Mr. Fisher. You just update the DA's office on what's going on. No abusive contact with CJ. And also, you do need to pay $150 within 60 days. You have a lot of bail here in this case, and I'm not going to make you have to pay that $150. I'm just going to take it from your bail and transfer it right over to the DA's office.
Thank you.
But the other bail does have to stay in the case
Yep.
for the 2 years.
The
And
600.
Yes, and if everything's good, then you'll get the money back. If something happens and they ask to revoke and terminate this agreement, that's just there for court cost fees and anything else that it would be needed for. But I am going to direct the clerk to send $150 to the DA's office to cover this. And then hopefully everything else will be good to go. Yes.
And I know you had mentioned, so in the continuing bond, the language will change from no contact to victim to no abusive. So that's
Yes.
great.
So you're going to have to re-sign another bail bond.
Okay.
Because they have to take that money out to lower it to $600.
Okay.
And then do that no abusive contact. So you just want to kind of hang around until Olivia can do that bond and then sign it, and then you should be good to go. Plus, she's going to give you a copy of this.
Okay.
So I am going to accept the deferred judgment of conviction, and good luck to you, Mr. Schumer.
Thank you very much, Your Honor.
All right, anything else, Mr. Fisher?
No, Your Honor, that was it.
All right, thank you. We are adjourned.
Thanks, Your Honor.
Well, that took a turn. The hearing for State of Wisconsin versus Jacob Schumer started out like your typical plea proceeding documents to sign, some back and forth on wording, and the usual run-through of constitutional rights, but it developed into something a little more personal and even moving. Judge Mogen, as always, was steady and respectful, keeping things clear without slipping into condescension. She balanced firmness with empathy, particularly once the conversation turned to Schumer's mental health and the events that led him to court. Her handling struck that professional middle ground, making sure the record was complete, while at the same time recognizing the very human side of what had happened. Jacob Schumer himself showed a surprising degree of openness. He was polite, cooperative, and fully engaged with the judge's questions. He acknowledged both his mental health condition and his past mistakes, even bluntly admitting that mixing alcohol with his prescribed medication was exactly what happened to trigger the incident. That kind of candidness is unusual in a courtroom, where defendants often hedge or stay silent. His comments about being hit with beanbag rounds and waking up with broken tibias had a sobering weight, but he delivered them without dramatics, more as lessons learned than grievances. It came across as sincere, and the judge seemed to respect that. Defense counsel Zachary Fisher did his part without overplaying it. He painted Schumer as someone who had already taken initiative seeking treatment, sticking with programs, and making progress long before the court demanded it. His advocacy was calm, not flashy, and his argument boiled down to he's learning, he's improving, and he deserves the chance to keep moving forward. Meanwhile, District Attorney Kevin Schmidt echoed that perspective, describing Schumer's conduct as more of a mental health crisis than a hardened pattern of bad behavior. Schmidt emphasized that the deferred judgment was a practical way to hold Schumer accountable while also supporting his rehabilitation. Both attorneys, though coming from opposite sides of the courtroom, landed on the same recommendation, a rare bit of harmony in litigation. The atmosphere itself was unusually thoughtful. This wasn't tense or combative. It felt almost like a group of professionals and a defendant working together to solve a problem. There were certainly serious undertones. Schumer's past struggle was no joke, but there was also a sense of cautious optimism. Even when he critiqued how excessive the beanbag rounds felt, he didn't do it angrily. He did it as someone trying to process and grow from a difficult experience. Judge Mogen's closing comments about sobriety and the dangers of mixing alcohol with medication were less like a lecture and more like a gentle but firm life reminder. In the end, the deferred judgment gave Schumer a structured path: 24 months of continued treatment, regular updates to the district attorney's office, and a financial penalty deducted straight from his bail. No fireworks, no moralizing, just a court recognizing that sometimes the best resolution isn't punishment alone, but a second chance tethered to responsibility. The result was a courtroom hearing that quietly underscored what justice looks like when it accounts for both accountability and humanity. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.